Once again, thank you so much. Here is Jessie Bifulco to talk to us today about Singles Guide to Estate Planning.
All right. Thank you very much. All right, so I'm going to start the slide presentation. And all right, well, thanks for your patience, everybody. So as we already said, we're going to do a guide to a single person's estate. Just a brief disclaimer, whenever an attorney gives a presentation, it's important to let you understand that this is general information. So it's really not appropriate to use for the basis of your complete estate plan, right? You want to get good advice and do a little bit of extra knowledge. And also, this doesn't create an attorney-client relationship. All right, our mission statement at the Penbay Estate Planning Law Center is to preserve family wealth and prevent needless family conflict. And I state that because it took me a long time to sort of boil down what I do as an estate planning attorney. I've been doing this a long time. I started out in practice with my father in New York City, and I got into estate planning early on because my father, I'm the seventh of 8 children. So my dad was, kind of venerable at that time. He'd been a lawyer for many, many years. He'd been a judge for 13 years. And he asked me if I wanted to go into practice with him. And I thought, wow, this is going to be great. I have an opportunity. I can go to the district attorney's office and prosecute criminals, or I can go and practice with my dad. So I chose to practice with my dad. And he was a World War II veteran, and he'd been in practice many years. So all of his old clients came back to him. He'd been a judge for 13 years, but they had, at this time they were grandparents and they were, getting ready for retirement, or they had already retired. So I immediately got into estate planning. I got a lot of experience right away. And these were people who, to me, they were like family members, because as a little kid, I'd gone to all the veterans affairs with my dad. And so they were all familiar faces. So I got into elder law when it was a brand new field, and they coined the term and estate planning. And I've been doing it ever since. So when I created this firm, on my own, I wanted to boil down what I did. So it came down to that: family wealth, right? We want to preserve your family wealth and prevent needless family conflict. So what does that mean in the context of single planners? And I think it's relevant and important to know. We want to preserve your family wealth. Well, what does that mean? Your assets, but also your prerogative about making choices for yourself. So an estate is not just, stuff. It's not just real estate and your jewelry and your flatware and your cash. It's also you, right? Your estate is any thing you're allowed to make decisions about, including yourself, where you live, how you live, what medicines you take and don't take. And you want to preserve that for what? You're preserving that family wealth, that asset, to be used in the manner and way that you would choose to have it used, okay? And with in the first instance, it's like that old thing they say to you when you get on an airplane: put the oxygen on yourself first, right? We all have things that we do. We help others. We participate in our community, maybe in church or maybe at the library or in various different ways. But we have to put the mask on ourselves first before we can help anyone else. So we're preserving our family wealth in the first instance for ourselves, for our security and peace of mind. And what about preventing needless family conflict? How does our mission statement reflect on single folks making their plans? Well, it's very important, right? Needless family conflict in the context of a single planner has to do with avoiding primarily unnecessary or unwanted court procedures. The court system is your default estate plan. In other words, if you don't make a plan, you don't make choices for yourself, you're just asking the court to do it for you. And they may choose someone to be your guardian or your conservator or your, or your successor trustee who you didn't choose, right? It might be somebody you might not have chosen yourself, okay? So in the context of single planners, preventing needless family conflict means choosing for yourself and also avoiding court proceedings, which are typically public proceedings. And a lot of times they're sending out notices to family members who you might not want them to send out notices to, right? Estranged family members who are defined as your heirs at law or interested parties in your proceeding. You don't want them getting a notice when you're vulnerable or even, after you died, right? There's a reason you make a plan. Okay, so our mission statement is every bit relevant to single planners. Now, what about life counsel? What is that? So when I, tried to be more deliberate about my estate planning, I tried to incorporate into my plan all of the wisdom that I gained in practicing with my father, and in getting, all of his, 50 years of legal experience representing families, and then what I learned from him and all the things that I learned. I wanted to create a way to not miss anything. In other words, when a client comes to me, I wanted to create a system that the client would tell me their concerns and goals, but also to inform them what could be done with good estate planning, so that it empowers them to tell me what they want, rather than just kind of cookie cutter, stamping on somebody who comes in some cliche plan, right? You're single, you're married, you're this, here's your plan. No, I want you to know what good estate planning is and tell me. So I called it life counsel. So when you see the little R in the circle, it's not because I'm, like Burger King, I belong to a franchise or anything. I just wanted to distinguish that process from the way other attorneys do it. All right. So for the purposes of this webinar, we're concentrating on single folks, people who may never have been married, or people maybe who were married, and they just are kind of on their own in terms of really close family members. Okay. We have other webinars that focus more on people who maybe they're still a couple and they have, closer family members that they live with. So this is a little bit different than that. All right. So what is estate planning? Number one mistake. Okay. I've done many meetings with clients who come in, and there's sort of a little bit of a pattern in what single people will tell me. They'll come in and they'll say, my plan is super simple. I really don't have anybody I want to leave my property to, or maybe I don't have a spouse, and so they sort of discount their intentions, which is really a bad thing to do, because it's not true. Like I said before, everybody I meet has a lot of moving pieces in their world, and the world would be very different if they weren't able to do what they do now, right? They may not see it that way, but it's true. So what I hear all the time is people come in and they say, I need an estate plan. I need to make a will, right? What does that mean? Well, they're assuming that a will is a plan. Okay, a will is just a tool. It's just one tool in a whole toolbox of estate planning tools that are used to make a plan. A plan involves intentions, and intentions need a goal. Okay, so a will is just a document. It's a legal document that allows you to designate beneficiaries and a personal representative, right? That's all a will is. But with a lot of folks that come in, they think that a will is a plan. I'm gonna show you how that's kind of a mistaken notion. So the first thing I want to point out about that is, when you're thinking in terms of a will as your estate plan, you're kind of going about it in the wrong direction, right? I'll always say, and this kind of shocks people, but I'm trying to be a little bit, to try and prick up your ears a little bit, but also be a little humorous. I say to them, you're not dead yet, right? Because they're thinking about it in the wrong way. You have to plan from the beginning. And the beginning is estate planning in stages. We can worry about who gets your stuff after you're gone later, right? We're going to worry about that down the line a little bit, but let's focus first on some issues that may be more important to you. Okay, we need to talk about you first, right? So unfortunately, I can't really see my notes, so that might create a little issue here, but I'm going to try and go through my estate planning phases. So when you want to make an estate plan, rather than just a document, right? In other words, a document is not a plan. A will is a document. It is not a plan. So you want to break up the planning into phases. And the first phase is, what are my goals and intentions while I'm alive and well? While I'm alive and have all my mental faculties, okay? What are my intentions? What are my goals? Okay, and I'm going to tell you what some of those should be, right? We'll go through that. The next phase of planning should be, what if I'm alive, but suffer from a temporary incapacity, right? You're on a ski trip and you break your leg and you're not going to make it back from Switzerland for an extra month, or you're down in South America birding and you're laid up for a couple of weeks, and who's going to feed your dog, right? That's phase 2, right? What are my goals and intentions if I'm temporarily set out of play? The phase 3 is, what are my goals and intentions if I am indefinitely incapacitated and I can't make decisions, and that might last until the end of my life. What do I want to see happen then with my estate? And then the final planning phase, and you see here, right, we're putting it last. What's my goals and intentions for my property after I'm gone? Okay, so let's start with this. Oh, wonderful. I made a slide out of it. So if you want to see that. All right, so let's talk about stage 1. What's important here in stage 1? I'm going to pause on this a minute in case you want to write this out. Okay, so just remember goals and intentions, right? All right, planning stage 1. So here's some of the things you want to think about in stage 1, right? And this is true of all my planners, and they love it. They love when we make a plan for them because it's an opportunity to consolidate and make a nice organizational document of what they own, right? Here's what I own. And you'd be shocked how many people, God forbid you get sick or something, it's next to impossible to figure out what they own, Even if we're trying to spend it on them and their bills, we sometimes can't figure it out. So you want to simplify. Do I really need 5 bank accounts and 3 investment accounts and a Vanguard account and 2 IRAs, right? Do I really need that? I've had this unregistered car in my garage for 6 years now. Do I really need that? Make a list of that stuff and get rid of anything you can get rid of, consolidate anything you can consolidate. And now you have a nice discrete list, right? You want to cultivate relationships in planning stage 1. What does that mean? Well, think in terms of future stages, right? Who do I have around me? That when we are among our life, when we're in our life, we don't look at it the same way as if we step back a foot or 2 and then just kind of examine, who do I rely on? Who relies on me? Who do I trust? Who do I use for, my accounting, my investments? Who are my good neighbors? Who would I borrow a cup of sugar off of if I couldn't get to the supermarket and I was making a cake, right? And you want to cultivate relationships with potential fiduciaries. I'm going to explain what that means in a minute. Beneficiaries, that's people you might want to benefit, including people and organizations. And I mean, you may already have these relationships, but you just want to look at them with a critical eye toward how are these people going to fit into my future plan in the other phases. Okay, so when we talk about fiduciaries, we're talking about people who can be trusted to act in your best interests rather than their own self-interest. Okay, that's what a fiduciary is in a general sense. Beneficiaries may be people you intend to benefit after you're dead, or organizations, right? You might have charities. So you want to get a little familiar with that charity, right? Is that charity doing what I think it does? Have I been involved with it? Maybe take a look at their minutes of the board meetings and say, oh, these board members are great. They really are on the same page as me. Or these board members are going in a weird direction. I don't know that, this organization is really the proper receptacle for my intentions. And then you want to vet actual professionals, right? If you're not using an accountant, maybe you should start to look one up, because if you do become disabled or incapacitated, who's going to do your taxes, right? Investments, potential people to play a role in your estate plan, a lawyer, things like that. A lot of my clients, most people are very self-reliant in Maine, and they're good at a lot of things. But you have to think in terms of what is it going to be like if I can't do some of these things or all of these things. You want to start vetting some of those people. Okay, so in trying to come up with ways or mechanisms to ensure my clients' plans worked, we developed we developed some ways to do that, some strategies. And I call them catch me if I fall mechanisms, right? Because that's what we're talking about. We're talking about in the next stage where you might have an incident where, you suddenly are forced to depend on others, right? So I was cooking the other day and, we were making food in a hurry and I don't know, I'm really busy and excited about law. So I don't spend a lot of time cooking anymore, but I used to love to cook and, but I was in super hurry. So what happened with the knife? Does anybody want to guess? So I almost, cut off my entire thumb. So I had to go to the emergency room, right? I was not expecting for this to happen. And literally I thought I was going to pass out or something. So went down there, people were wonderful. They patched me right up. I didn't have to wait very long. And I was back at home and cooking in no time. But what are some of the things that, we build into these plans to try to avoid if something happens in the future, to avoid us, to make sure that our reasonable expectations about how our money is spent, how we want it to be spent are ensured, and also about who's going to do these things, right? So I call that assurances of fidelity and redundancy of design. So assurances of fidelity are just ways to make sure that, or little insurance policies about whether our chosen fiduciaries should come through when we need them. They're going to come through in the clutch, right? So my assurances of fidelity in my little story were, I went to the hospital because I knew the doctor was licensed there, okay? And as coincidence would have it, the emergency doctor, room doctor was actually a client of mine. So I don't know, I feel like I got special attention. Maybe they just treat everybody nice. But so my assurances of fidelity were, she's got a license. She's got malpractice insurance, right? I'm perfectly comfortable with her treating me. She's working in an institutional setting that has longevity, that will have replacement doctors if she retires, right? So those are assurances of fidelity about some fiduciaries you might choose. Redundancy of the design means having people who have overlapping responsibilities so that if one of them, breaks down, the other one can take over, okay? All right, there's my little animation. Isn't that fun? The pillows. All right, so here's some assurances of fidelity. And we're talking in the context of choosing people who are going to play roles in your future plan if you are ever incapable of doing one or more of your activities of daily living, right? If you're incapable of getting out and shopping, if you're no longer capable of balancing your checkbook or paying your bills, if you can't get to the doctor, okay? So here's some of the indicia, some of the indications that somebody might be loyal. Fidelity means loyalty, right? Do you have a long-standing relationship with that person or institution? Do they have a financial incentive to do a good job? Okay. Do they have a reputation in the community? Do they have professional liability insurance or institutional insurance or a bond? Do they have institutional stability? Okay. Now, not every single fiduciary or trusted advisor is going to have every single one of these assurances, but most of them should have at least one or two, right? Because that's how we're going to ensure that if it turns out that you need help, or that your plan, some of the things you want to continue to happen, even if you're not the one calling the shots, these are ways you're going to ensure that those people that you rely on do it, right? So I'm going to tell you a story about Bill, okay? So Bill was a veteran, and he didn't have any kids, and he wasn't married, but he managed to, build up a decent estate. But there was one piece of property in his estate that was really important. It was a house, and it was in Massachusetts, okay? And this house had been in the family for a couple hundred years. It was really important to Bill to make sure that his nephew got it, because, even though Bill, didn't, have a very extremely close relationship with his nephew, he still wanted to respect his ancestors and make sure that this house passed on to his nephew. And Bill was getting a little older and he lived in a small town in Maine. And he decided, you know what, I might need some help one day. I'm going to make a power of attorney. Maybe he saw something on the AARP or read a magazine article and they said, you should get a power of attorney, right? So Bill goes out and he gets this power of attorney at the lawyer's office. Now, when he goes to the lawyer's office, remember my story about, or my admonition about the difference between documents and a plan. Bill goes into the lawyer's office and he says to the lawyer, I need a power of attorney. Okay. Now, what mistake did Bill make? Remember what I said about intentions and goals. Bill had an intention and a goal. He didn't express it. He just said, look, I need a power of attorney. So what does the lawyer do? He doesn't interview Bill and ask him about his intentions because, that's not the way he does it. He says, all right, I'll make a power of attorney. Who's going to be your agent? Okay. So for those of you who are not sure what a power of attorney is, it is a legal document that allows you to give your legal and financial powers to someone else. It can be one person, it could be more than one person. And they have these powers in addition to you, not in substitute of you. Okay. And people frequently make them because they're afraid one day they might have a temporary or prolonged period of incapacity. And they want someone out there who can get a hold of their banks, their money at their bank account and pay their bills, right? But if you've ever seen a power of attorney, what does it look like? Has anybody ever seen one?
Oh, sure.
Yeah. Have you seen one, Bob?
Yeah, I've got one.
Yeah.
That allows my daughter, one daughter and another, the first daughter, to exercise my authority for me.
Yeah.
For all my legal affairs.
Excellent.
Commitments financially.
Yes, that's right. So Bob said it gives authority to people he chose. He chose his daughter for his finances and his money. So what does that mean? Well, it's a list of powers. You have the power to do, real estate, banking, investments. You have the power. But what's missing? What you're supposed to do with that power, right? What are you supposed to do? Are you supposed to spend every last penny keeping me at home, build an elevator, hire nurses, whatever it takes? Or are you supposed to take that money and put it aside for someone? Or do I have a nephew who's supposed to get this house that was in my family for 200 years? So the problem with the power of attorney is it's all powers, it's all authority and no instructions. So with my friend Bill, the veteran, right? He thought to himself, well, who am I going to trust? So what are my assurances of fidelity, right? Well, he had this long-standing relationship with his Army buddy. So he makes his Army buddy his agent under his power of attorney. And then one day he decides it's a great day to lose his marbles. Poor Bill loses his marbles. And Bill's lawyer calls up his Army buddy friend and says, Hank, Bill made you the agent in his power of attorney. He trusts you implicitly. And Hank says, all right, well, what do I got to do? Well, the lawyer says, well, Bill needs nursing home care. He can't live at home. So what does Hank, his Army buddy friend, do? Well, he listens to the lawyer. He sells the 200-year-old house and pays the money towards the nursing home care. Even though his buddy Bill had other monies they could have used, the lawyer told him to sell the house and the nephew didn't get it. So that's what I mean about intentions and plans, right? If you have a goal or an intention, it should be reflected in your documents because a legal document is not a plan, okay? So let's talk for a minute about aging in place, okay? This slide kind of looks out of place, but so aging in place is kind of relevant to that story, right? Because sometimes we're thinking in terms of phase 2 and 3, where a lot of folks, it's their intention not to spend a significant portion in their lifetime, the end of their life, in an institutional setting. So they have to think a little bit about how they're going to make that happen. It doesn't happen by accident. So you have to think, where I live, could I live here if I couldn't drive? I'll tell you a story about Beth. So Beth had a very nice house in a country setting. And her husband died and she was on her own. And, she was doing pretty good for a while there. But then one day, something happened when she was driving and they took away her driver's license. And now all of a sudden she's in her home and she doesn't know how to get groceries. And her expenses became exponential because she's got to hire someone to get groceries. So this little thing, this little issue in a rural community, really was torpedoing her plan to stay at home. And sometimes, when we get, when we're vulnerable like that, it can be really hard to make a decision. And, and depending on the market, some more suitable places to live, might be hard to get in, So right now we have, they have some communities that they're developing where your medical care, your shopping, your food, everything you need is there. Some of these places are in very nice settings. And if you become incapacitated while you're there, you don't have to move because the level of need that you have, the care actually elevates as you need it. But there are waiting lists for the nicer ones, right? Or maybe that's not important to you. Maybe you just want to make sure that some other person or entity inherits your property. You have some intention there. Or maybe it's something in between. Maybe your house can be, renovated in such a way that as you age, you can stay there longer. Statistics show that people who do this, who age in place and who make a plan to age in place, actually end up living out their lives at home. And if they do need institutional care, it's only for a very brief period at the end of their life. So it's worth giving some thought to how that would look if you lost the ability to drive or you lost the ability to go upstairs or whatever. Do you really want to age in place? Okay. So this is just a little excerpt from a planner that we give out to people who are single planners who come in, and we give them a nice, it's a 4 or 5 page workbook. It's like a little, you're doing your homework again. It gives you a good way to sort of focus on some of these issues. Okay. All right. So what do we mean by, we spoke a little bit about assurances of fidelity. What do we mean by redundancy of design? So here you see this list of roles, and it seems a little bit confusing. Maybe you're not really sure. We're going to go into what these things are, but each one of them is designed to help you achieve your goal at those different phases. Okay. Some of them are going to help more if you become incapacitated. Some of them are kind of unnecessary unless you become incapacitated, but working together, they're going to ensure that your plan works regardless of your contingency, whether you need a lot of help or you need a little help, or it's just, something at the end of your life. Okay. So this is what I mean by redundancy of design or overlapping powers. Okay. So I'm going to explain what some of these roles are so you kind of get a sense of what I'm talking about. But in a practical context, let's imagine that you, in phase 1, your goal is to make sure you're in charge of all of your stuff, right? While you're alive and have all your mental capacity. But you want to make sure that if something happens where you lose some of your mental capacity, it's not going to be expensive for your successor to take over. It's not going to be expensive or confusing for somebody to help you. Okay. So you might appoint some of these roles. Okay. So how are we going to ensure that we're protected? Well, we want to name different people to these roles and have them notify each other if something happens. For instance, if I'm acting for myself one day, but then all of a sudden I have an incident, maybe I want my successor trustee to give a notice to the agent in my power of attorney. It says, hey, power of attorney, I'm taking over. Why would that be useful? Because if the successor if the successor trustee is not doing a good job, the power of attorney can keep an eye on, right? They can go to court and say, hey, the trustee's not doing a good job. We got to follow up on that. And likewise with the care manager. A care manager is meant to oversee and coordinate care if you need a lot of care, right? So if you're in a medical condition that might be phase 3, where you are, indefinitely incapacitated, it's really hard to advocate for yourself. And, your healthcare power of attorney might be a really good trusted person, but they may not have any expertise in healthcare. So maybe you want your successor trustee to hire a care manager whose job it is to manage this. And they become like a liaison between your advanced directive for healthcare and your successor trustee. All right. Are we paying people the right amounts? Are they doing what they're supposed to? Are we meeting our goal? Okay. So let me explain what that means. So let's talk for a minute about your trust. Okay. I'm going to explain one of the key estate planning tools that we use, especially with a single person's estate plan, is a revocable living trust. Okay. Now, remember when I was talking to Bob about powers of attorney, I said that they were all authority and no instructions, so that if he had a specific intention about his property, like my story about the veteran who he wanted to leave his house to his nephew, but he never told anybody, right? Well, you can put that information in a revocable living trust, because the revocable living trust is your instructions. Okay. These are instructions. If you think of a revocable living trust like an open box within which you put all your stuff, right? You can put your house in there, your investments, everything belongs to this trust. And while you're alive and well, that's in planning stage 1, you are in complete control of that. No one else has control of that. You can spend your money, you can buy a new house, whatever you do, you can do it. It just becomes relevant and important if you lose your marbles, okay? I hope that doesn't offend anyone. It just sounds a little better than losing your capacity, right? Capacity is hard to say over and over, but so if you lose your marbles, what happens with this box? You've already said who is supposed to take over after you, and that's your successor trustee. You're the trustee to start with, but if you lose your marbles, you name someone else, okay? Somebody who you have assurances of fidelity for, right? Somebody has some of those assurances of fidelity. How are we going to know if our successor trustee is supposed to take over? Well, we can use something called a disability panel, okay? So remember my overlapping stuff here, right? So if I am no longer in charge of my trust, my successor trustee is going to take over. But we have these little alarm bells to let that trustee know when he or she should take over. And they're going to be called my disability panel. These are folks. It could be one or more than one person. They could be relatives. They could be friends. These are people who might say, I tried to call Joan the other day and she didn't answer her phone. So I went over and she had totally forgotten that we spoke about meeting on Wednesday. I went to go see Bob and he was writing out a check to his health aide. I thought the health aide was paid by insurance. I went to see Jane and her mail was piling up. Looks like she had 2 weeks of mail and she hadn't collected the rent from her tenants. So these are your little alarm bells. They may have you may even give them the authority to speak to your doctors if they're concerned. These are people you feel comfortable and close enough, who know you well enough to call your successor trustee and say, hey, we think that Joan or Jane or Bob is not capable of managing his or her affairs anymore. I think it's time for you to take over, right? And then you may, if you want to make sure of it, you may have that trustee send a little note to your power of attorney, right? Say, hey, agent, the disability panel just told me I got to take over for Jane. I'm going to manage Jane's affairs. And in the trust, it says I'm supposed to give you notice. So here's the notice. You see how that works? And maybe the notice goes to the advanced directive for healthcare too, right? So I'm going to get into the advanced directive for healthcare in a minute. You know what? Maybe I'll address that now since I keep referencing it. So when you go to the hospital, like I did when I cut my thumb, right? As soon as they are sure you're not going to bleed to death, they ask you if you have a healthcare proxy, right? Do you have an advanced directive for healthcare, right? They're always asking you that. And what does everybody think that document is? Well, it's a legal document, first of all, but they call it, the end of life care thing, right? And some more crass people call it the pull the plug document, right? But it can be used for more than that. In other words, in a good estate plan, that's not what it is. It's an agent. It's somebody who can make healthcare decisions for you, which may include whether you live at home or not, right? Whether you have a nurse or not. Those decisions, if you can't make them for yourself. So again, it's another agent similar to a power of attorney, only instead of legal and financial powers, this agent can make medical decisions. But you can also say in your plan, hey, if my successor trustee ever takes over, I want a note to go to my advanced directive for healthcare agent. I want my healthcare agent to know what's happened because maybe that I need them to be triggered to find out, right? Maybe your goal is to stay home longer. And now all of a sudden the advanced directive person needs to know that you're no longer in charge of your checkbook. Okay. So that's how we do it. That's one of our ways to make sure that your plan is carried out right. We spread out some of this authority and we make sure there's notices going back and forth, all geared toward whatever your particular goal is. Okay. So we covered the disability panel. That's a way to trigger your successor trustee to act. Okay. So a successor trustee is the person or persons who take over the management of your trust assets during your incapacity. And also they can act after you die. Okay. So another efficiency, another reason why you might use a trust instead of a will is you actually change title to your property before you die. In a will, all your stuff still belongs to you when you die. Okay. So there's a little bit of an efficiency there because changing title to your property yourself is relatively simple and cheap, right? You sign a deed, you change the bank account over, in one afternoon, you've done everything you're supposed to do. If you die and leave that in a will instead, all of that stuff costs, a ton more, right? It costs, because it's probate. Now we got to change title to your property and you can't sign papers anymore. We got to go get a judge permission. We got to publish it in the newspaper. We got to go around with certificates and death certificates and prove all that stuff. Well, guess what? If you made a revocable living trust, you avoided all that. But the reason it's important while you're alive is because remember, your instructions go along with that box. So if you put everything in the box, if you transfer title to this trust and you do experience a period of vulnerability before you die, the instructions will govern those assets. Okay. A power of attorney would allow somebody to transfer title to your property, but it has no instructions, right? What those instructions look like is entirely up to you. And how are you going to figure out what they should look like? You're going to come up with a goal, right? What is my goal? What do I want to see happen with my stuff if I'm alive but disabled? What do I want to see happen with my stuff after I die? So you put it all in that trust instrument, okay? All right. So what's a trust advisor? Again, this is another way, another little check and balance that we try to make sure that your plan is carried out the way you want. This is someone who can look over the shoulder of your successor trustee if somebody thinks they're not doing a good job, right? Because we can name trustees, but they may not end up serving, or someone different might end up serving, or they might just change. Maybe we chose someone who was really had a lot of assurances of fidelity when we started out, but then when we became disabled, they got gambling debts or something, who knows, right? And now all of a sudden, one of your advanced directive for healthcare calls up your trust advisor and says, no, Jane's bills haven't been paid. I'm a little nervous about the successor trustee. So the trust advisor can demand an accounting and fire and replace the trustee. Okay. So we call the trust advisor a watchdog. And they're like a mechanic because sometimes these trusts, they have some, sort of complicated legal language in them to try and make sure that your taxes are no greater than they have to be. There's certain things in there that provide creditor protection. So there's certain technical things in trusts that sometimes need to be updated. So we want somebody out there who can do that. And that's a trust advisor. Okay. I went a little out of turn, but the power of attorney agent, right? That's another one of our fiduciaries. And they have legal and financial powers. okay? We spoke briefly about how they have all this authority, but we didn't touch on why legal powers are useful and why you would still need an agent in a power of attorney, even if you have a successor trustee, because you may need to sue someone or defend a lawsuit, and you may be mentally incapacitated, right? So an agent in a power of attorney has that power. They can deal with contracts, insurance companies. They can deal with legal benefits you might be entitled to, government benefits, the Veterans Administration, Social Security. So even if you have a successor trustee, you still need an agent in power of attorney, okay? And care manager, we briefly touched on that role. And again, not every one of these roles is going to be incorporated in every plan, but if it's logical for the goal you have, then you're going to consider using these people, right? Sometimes we appoint a care manager. Sometimes we merely put in the authority to appoint a care manager because we want our trustee to know that such a person exists. Sometimes these documents are teaching documents. In other words, you could make a really short trust that doesn't say much, or you could make one that says, hey, trustee, by the way, it's one of my goals to stay at home. And I think it would be useful for you to know that you are allowed to hire a care manager. And here's what care managers do, okay? Or maybe you're like Susie. Susan, was on her own. And she was, kind of had difficulty getting around. She couldn't drive anymore, but her disability came on slowly. So she had built up a network of people to help her, okay? Taking her places. She had saved up her money and budgeted. So what Susan did is she actually literally hired a care manager herself in anticipation of a day that she might not be able to make decisions anymore, okay? So she was able to vet the person, know their qualifications, build it right into her estate plan and her trust. What are Hipaa agents, okay? So sometimes we want to give somebody the ability to call our doctor or ask about our health, but maybe they don't have authority to do any more than that. And these are like alarm bells again. Obviously your advanced directive for healthcare agent, they're going to be a Hipaa agent as well, but their document says that they're only able to act if you lose your mental capacity, right? So that they have to establish that before they can talk to the doctor. But you may want somebody in your life, like your disability panel, to be able to talk to your doctor even without you being proved to be mentally incapacitated, right? If you have someone close to you in your life who checks in on you once in a while, or maybe your disability panel, you might want to give them that authority. All right. So we've covered some of the reasons why single planners should focus on putting the oxygen mask on first rather than the end of their plan, which is who gets your stuff, right? We've spoken a little bit about some of the ways you can make sure that your plan is carried out. One of those is actually having a goal for each one of those phases. And then the other is those assurances of fidelity and redundancies of design. We spoke a little bit about the different roles that people play in our plan. Now we're at stage 4, where you get to have a little fun benefiting others, right? Where you're going to give away your stuff. Who's going to get the benefit of your estate? Okay. And that's where you want to think about your intentions. Is it going to be people? Is it going to be charities? Is it going to be your horses? So we have individual beneficiaries, charitable beneficiaries, and then we also have something I call legacy or directed giving. Okay. So I'll talk a little bit about individual beneficiaries first, then charitable beneficiaries. So individual beneficiaries, a lot of times when people are making their documents, they say, all right, well, we're going to make a will. And I have 3 beneficiaries. And, there's Jim and Sue and Bob, right? Sorry, I keep using Bob's name, but it's one of my favorites. So Jim, is Jim's pretty stable. He's a doctor, and Sue, she is she's in a longstanding marriage, but we're a little bit concerned that she might get divorced one day because her husband and she don't get along. And then Bob is a little young, he's a minor. So when you leave property to these people, right, you can say, all right, well, let's hope for the best. We're going to give each one of them a third of the estate, and boom, it's done. And then what could happen with Sue is she could get divorced and her husband could get half of it. What could happen with Jim is he's a doctor. He could get sued for malpractice and they could get it. What could happen with Bob is he's still a minor. He's a kid. His guardian could take the money, or maybe he's only 18. He's still at that unwise stage where it seems like more fun to buy a motorcycle than to go to college, So maybe that's not a good idea to make these outright gifts. So again, we want to think of our goals and our intentions. If our goal is to help, but also sometimes to pass on a little bit of our own values, you can make your gifts in trust. So you can make a trust in your plan that protects the beneficiary who's a doctor from malpractice claims, right? That doctor can have control over his gift, but it can't be taken from him by someone who sues him. Sue, we can make sure that her husband can never touch the money, even though she gets the benefit of it by using a trust. And for that minor, we could say that trust, the minor won't have control over his or her money until they reach age 25 or something. So you don't have to make outright gifts to individuals. What about charitable? So this talks about beneficiaries. You can put incentives in those trusts too, like the minors will get control of the money if they get a bachelor's degree, or if they, manage to create a successful business, or maybe if you want to encourage them if they get married and buy a house, you can put your own incentives in that trust to allow that money or that gift to be used in ways that you think are good. Okay. Pets. A lot of people have very, a great deal of concern about their pets. It may be a dog, it may be horses, it may be, any number of animals that are part of our family, and you can incorporate them into your plan. And caring for pets in a trust doesn't happen by accident, because under the law, technically, animals are just property, So if you don't put in your intentions about them, then they may not be properly cared for, okay? And legacy planning. So this is what we talk about when we're trying to benefit a cause or an endeavor, or a charitable endeavor, or a charity we like, okay? So you want to, a lot of my clients, or a lot of people today, have socked away a lot of money in retirement, and they don't touch it, right? They're retired, but they're not spending it, right? So there are ways to use that money to benefit your a charity and get some of the benefit yourself. Sometimes I've had clients come in and I say, in your plan, did you want to make any gifts to any people or charity? And they'll say, I'd like to make a gift now. I want to see the smile on their face. So you could do that with a charitable lead trust, where you're making a gift presently to a charity and you're getting a tax deduction. And then you can still get that stream of income during your life with the remainder. And there's also a charitable remainder trust, where somebody is going to get a stream of income for their lives, but there's a chunk of money that goes to the charity at the end. The reason I speak about these charitable trusts in context of retirement funds is because a lot of times you can get a reduction in capital gains for when you use retirement money, right? Usually with IRAs, you take the money out and pay a big income tax on it. But with these trusts, you can get a stream of income and benefit a charity, okay? Another way to benefit a charity is with just an outright gift to the charity, or you can create a donor advised fund. where maybe there are people in your life who you want to be able to direct that money because you want them to choose from various charities. Or if a charity's board of directors does something you don't like, maybe you want that person to decide to give the money to a different charity that year. So you can do that with a donor advised fund. And then you can also, if you have enough money in property and you want that to go on for years, you can create your own charitable foundation or charitable trust. So then those trusted advisors who protected you during a period of incapacity, some of them can carry out your intentions, your charitable intentions, by continuing a trust. Okay. So those are some of the phase 4 planning. Now, perhaps it would be a good time to take questions, and that way I can stop the slideshow and see if anybody has questions. Does that sound good, Julie?
So does anyone in the room have any questions?
Yes.
The difference between revocable and an irrevocable trust.
Yes.
Why would I do one versus the other?
Okay. What's your name?
Pam?
Thank you, Pam. That's a wonderful question. Okay. So revocable trusts and irrevocable trusts have very different uses. Okay. So when I spoke about trusts in this workshop, well, the only trust I was speaking about was revocable living trust. I was not referencing irrevocable trust. Okay. So irrevocable trusts are generally used to gain creditor protection for you. Okay. So what does that mean? It is in relation to unknown or future prospective creditors. Okay. So let me give you an example. There are lots of different ways to use them. One context may be a business owner. Okay. So we have a business owner. He and his wife started a business at selling ice cream. Okay. And they spent their whole lives building up this business. And now they're getting older. They don't want to make ice cream anymore. They found somebody to buy that business. Okay. Before they retired, the business was going great, right? The income was great. It was on a good footing. They had everything perfect. Now they reap the reward and they get this giant sum of money for their ice cream business. But they're afraid that if they get sued, or if maybe the new owner, isn't good at running an ice cream business and sues them and tries to say that they did a bad job building their business, they can't go back 40 years and start all over again if they lose that money. So they put it in an irrevocable trust, and that trust protects it from that future prospective lawsuit. Okay. There are limits on how they can use the money and who manages it, but ultimately they're going to get some creditor protection. Okay. Another way that people use irrevocable trust is it's a pretty common way, because this is a common concern. A lot of folks are worried that they may spend the last 4 or 5 years of their lives in a nursing home, and it's going to be so expensive, it's going to wipe out their whole estate. They don't mind paying something for it, but they don't want to lose everything. So they'll take something valuable of their estate and they'll stick it in an irrevocable trust in case in the future they have that nursing home expense. They reserve a lot of their money. In addition, they have, some money that they kept. And if they do go into a nursing home, that gets spent. But once that's all gone, what's in the trust is protected. Okay. Those are kind of practical examples. There are a lot of different reasons to use irrevocable trusts, but you have to keep in mind with irrevocable trusts, you have to give up some level of control over what's in that trust. So for a lot of people, that's just too much to lose. For instance, if you put your house in an irrevocable trust, you can't get it back. You might be able to reserve the right to live in that house. Maybe you still have the honor and privilege of paying for that house because you're living in it, but you can't take it back and sell it and buy another house and mortgage it, and, because it belongs to the trust. So that's the main difference between revocable and irrevocable trust. Revocable living trust, great for administration, great for saving probate expenses, great for providing for your instructions if you're alive but incapacitated, right? We don't need a guardian now. We don't need a conservative. We created this wonderful trust, but it's not really very good if you're interested in creditor protection. Okay. Thank you, Pam.
Deb has a question.
Okay.
Right in the chat.
Oh, good. Okay, great.
Deb is the purple one.
Deb is the purple one. Thank you. Okay, do or should estate attorneys typically offer a no-cost initial meeting to help a potential client determine whether they're a good fit? Oh, my gosh. So was this, are you a plant? Did you ask me this because you knew I was going to answer it? So that's a great question. So the whole notion of a free meeting, we don't really do that, but I feel like if you have spent time to learn about estate planning, that I'm willing to give you some of my time. So yeah, we do that in a sense. We're not going to have like a 2-hour meeting with you because then it starts to get into actual planning, you know, and that's the work of it. The work of it is figuring out what's going to work best for you. But what we do at our firm, the Penbay Estate Planning Law Center, is we ask for some basic information from you, which would help us quickly audit some of the issues you'd have. And with our plans, we've tried to make it simple for clients, because the old way, I found people just found it confusing, where, you know, we bill by the hour and they're not sure how long it's going to take. So we just basically create fixed fees. So what we do is have a little meeting, ask you some questions, allow you to ask some questions and answer them, and then say, based on what we've learned, we think this plan would work well for you, and here's what it costs. And then if you like the idea, you go forward, we have the interview, we do the whole life counsel process to design it. Okay, thank you.
I will go ahead and allow people to unmute themselves. So if there's anyone who would like to go ahead and unmute yourself and ask a question, you're welcome to do so. You may want to just,
Okay,
Courtney may have unmuted herself.
all right,
Yeah, but
Courtney.
I don't have a question right now.
Thank you, Courtney. We know it works.
I got a quick question.
Yes.
Going back to the trusts, specifically, are those time sensitive as far as how old you are and when those things can go in, be implemented? If somebody's near the end of their life, can they kind of try to get it together quickly and without some kind of penalty? You know, I hear a lot of things about 5-year rules and,
Yeah.
and all that.
Yeah. So thank you. What's your name?
Ben,
Ben, thanks for that question. So Ben's asking something that I think is related to Medicaid or main care planning. Very common question. There are things that can be done, and there are a lot of techniques and tools to try and preserve assets and get main care and Medicaid coverage for nursing home benefits. But you need, you know, obviously you need to be able to agree to them. So if you have mental capacity, an attorney like myself would sit down with you and say, what is the exact circumstances? What are you trying to do? Are you being discharged from the hospital to a nursing home? Are you living at home and you're just afraid you can't live at home much longer? Are you married? Are you single? And then we come up with a plan. So the trust part of it is not as useful if you're basically in a nursing home already. It's not as useful, but there's still things that can be done. The problem is sometimes when people are in that situation, they don't have the capacity to sign documents, right? So that's where a power of attorney comes in handy, assuming it has the right powers in it, and assuming that that's what the person would have wanted you to do, right? Does that help?
yeah, it does.
Yeah. Thank you, Ben. Yes, Pam.
Now, it was my understanding that a trust kind of remains private. It will not, you know what I mean, go into probate, and sums and things will not be made public. Is that correct?
That is partly true. So there's a lot of privacy involved with trusts, but in certain states, they have given certain rights to notices to beneficiaries of the trust. So in Maine, a trust is pretty private. In other words, there's not going to be probate, no notice in the paper. You don't have to publish in the probate court how much money you have. So there's a lot of privacy involved. But there are some certain rights that your beneficiaries would have. So let's say if you left money to your nephew, Sam, and to Sam's kids, if Sam died, Well, they might be able to ask the trustee for an accounting, for information about what the trust owns. And there are some people who don't even want their beneficiaries to know what's in the trust, right? Perhaps you're afraid that the beneficiary would demand more money, right? You just want them to have what the trustee says. So there are ways to gain more privacy if you need it. But the default is no public knowledge. It's just, the document is private, but some of the beneficiaries may have a right to ask for information. Thanks. Yeah.
I arrived late because of a doctor's appointment and I can't hear you either. So what's the best way for me to catch up to what's been presented so far?
Do you have an email address?
Yeah.
I can send you the recording.
Oh, good. Thank you so much. Sorry to interrupt.
No sweat. Any other questions?
Just one other.
Yes.
sorry.
Yeah.
I was kind of told that I needed a trust because I have property in 2 different states.
Oh, yeah. Yeah, that's a great reason to make a trust. So remember how I was talking about efficiencies,
Mhm.
saving money? Okay. So I had a client, well, let's imagine somebody has real estate in multiple states and they have a will, right? So with wills, they're public proceedings and you need a court process to be appointed the personal representative. So a will is a legal document that has 3 things in it: the name of the deceased, the name of the person who died, the name of the person who's supposed to carry out their wishes, that's called a personal representative or an executor, and the name of the beneficiaries. But in order for that personal representative to be appointed, they have to get court permission. And why do we do that? Because nobody can sign your name to a deed. You've died, right? So then they got to go to court. They got to publish in the newspaper. They got to do all these things just to get permission to sign a deed in Maine.
You can read that.
But what about the deed in Virginia and the deed in Arizona and the deed in California? Guess what they have to do all over again in 3 different states? So if your trust owns it, remember what I said before, you're making this box with your instructions. And then in that box, you're going to put this stuff. And those deeds that you make while you're alive,
And the,
they're cheap. You don't need any court permission. You don't got to jump through hoops or publish in the newspaper. You just say, hey, make me a deed to my trust. So my name to my trust, boom, done. Now, it doesn't matter how many states you own property in, there's not going to be probate in any of them. Okay. So what costs you a couple $100 to fund your trust, or maybe a little more in some of the fancy states like New York, where there's 16 pages of deed stuff. But even then it's cheaper than probate in New York, right? And that way you avoid that expense and that inconvenience and delay. Okay. So yeah, that was a great question. Yeah.
Kathy,
Yes,
repeat
okay.
that.
Okay. Does an LLC do as you are saying about a trust? So I think Courtney is saying, Katie. So Katie is asking, can I use an LLC to do some of the same things as a trust? Okay. No, it's different. It's a little different. LLCs have different uses. We do use them in estate planning, but for different things. Sometimes they play a role in asset protection. Sometimes they play a role in gift tax. Sometimes, in really large estates, sometimes they're a way to share management of property, like with a family camp or something. But they're not going to be like the analogy to the box with your property in it, with the instructions that go with your box. An LLC won't work that way. Okay. It just doesn't, it's not set up to do that.
Did you have an opportunity to answer Deb's question, which was right before Katie's?
No, I don't think so.
Right
Let's
there.
see. Can a person prepare a set of instructions that is legally binding but does not take the form of a trust? Or is a trust the only vehicle for conveying one's wishes? Well, the beginning of your question kind of describes a trust. So a trust in its simplest form is giving property to someone else with instructions about who's supposed to benefit from it, right? So I'm not really sure. I mean, if your instructions, so I guess legally binding instructions, in a sense, that's what a will is, right? because you haven't changed title to your property yet. So you're saying, you know, here are my instructions, do this, what, if I die or if I become incapacitated, right? So there's got to be more to it than that. I think that ultimately, you know, this goes to sometimes we're trying to be a little too clever and we try to avoid things, but trusts, you know, I think sometimes people think that they have to have tons and tons of money to make a trust, or that it's only practical if they have a really large estate. It's not that way. Okay. It really is about having your instructions be legally enforceable, right? So I can't imagine a circumstance where you would take a chance that your sort of pseudo trust or your instructions would work, right? I don't know that they would be legally enforceable. Ultimately, if somebody didn't want to follow them and somebody else wanted them followed, they would go to court and try to have them construed as a will or a trust, right? They'd say, these are legally enforceable, right? Or maybe it's some kind of contract. So you don't ever want to fall into that category of, now we need a judge to figure it out, you know, when you're doing your estate plan. It's just not worth it. Thanks for that question. Okay. Any other questions?
Oh, I think.
Wonderful. All right. Well, thank you so much.
And thank you all very much for participating in this, our very first hybrid session. I hope it went well for you. And I will be sending out an email after this that will have a link to the recording once I get it up on our YouTube channel. So you can go back and look at that as a reference. And one of the things for those of you who attended on Zoom that I'd be really grateful for is if you could just send me a quick email back after that and let me know why you chose to participate on Zoom today as opposed to in person. We're trying to navigate this whole strange world of doing, you know, programming in person and on Zoom again. And we're just curious, are people still concerned about COVID? Is it just super convenient to do the Zoom? So whatever your reason was, I'd love to hear about it. All right, we won't take up any more of your time. Have a wonderful rest of your day. Thank you.